Michael Torres, a 42-year-old civil engineer, stood in his backyard on a sweltering July afternoon, staring at the certified letter in his hands. His neighbor of 6 months, Patricia Hendricks, was suing him for ownership of the custom saltwater pool he'd built 3 years ago. The pool that sat entirely on his property. The pool documented in every city permit, every contractor invoice, every property survey. Patricia claimed it was partially hers because she could see it from her kitchen window. For 3 months, she'd been using it without permission. Today, that entitlement was about to cost her everything. Before we dive into how Michael turned Patricia's outrageous lawsuit into her worst nightmare, if you love stories where entitled neighbors get exactly what they deserve, hit that like button and subscribe. Now, let's see exactly how this unfolded. This is a story in 3 parts. The violation that pushed a reasonable man to his breaking point, the confrontation where a lawyer's greed met cold reality, and the resolution where a courtroom became the stage for perfect justice. The violation began innocently enough, a new neighbor moving into the house next door, friendly waves across the fence. But Patricia Hendricks wasn't interested in being neighborly. She wanted what Michael had built with his own money on his own land. What started as audacious trespassing evolved into something far more sinister, a calculated legal attack based on pure entitlement. Michael watched as this woman twisted facts, manufactured evidence, and convinced a lawyer that her delusion had merit. The emotional toll of defending what was rightfully his, the sleepless nights reviewing documents, the violation of having his integrity questioned, all of it built toward one explosive moment. The confrontation didn't happen in a backyard argument. It happened under fluorescent courtroom lights, where Patricia's carefully constructed lies met Michael's engineering precision and documentary evidence. The power shift was seismic, the revelation devastating. And the moment Patricia's lawyer realized his mistake was almost as satisfying as what came next. The resolution delivered justice so complete, so thorough, that it became a cautionary tale whispered at neighborhood gatherings for years to come. Here's exactly how it happened. Michael Torres had purchased his property at 847 Oak Ridge Drive in March 2019, drawn by the expansive backyard and the mature oak trees that provided natural privacy. As a civil engineer specializing in residential construction, he immediately saw the potential for the pool he'd always wanted. By June of that year, after securing all necessary permits from the city, hiring licensed contractors, and investing $47,000, his dream saltwater pool was complete. The rectangular design measured 20 feet by 40 feet, positioned a full 15 feet from every property line, with stamped concrete decking and integrated LED lighting. Every measurement, every permit, every invoice bore his name alone. Patricia Hendricks moved into the adjacent property at 849 Oak Ridge Drive in January of this year. She was 51, a self-described lifestyle consultant who worked from home, and she made her presence known immediately. The first incident occurred on a Wednesday afternoon in early February. Michael returned from his office to find Patricia floating on an inflatable lounger in his pool, a magazine in one hand, and a wine glass balanced on the lounger's cup holder. When he approached, stunned, she'd smiled and said, "You don't mind, do you? I can see it from my kitchen, and it seemed a shame for it to go unused during the day." Michael, caught off guard and naturally conflict-averse, had stammered that he preferred she ask first. Patricia had laughed, a tinkling sound that set his teeth on edge, and replied, "Oh, don't be so uptight. We're neighbors." 2 weeks later, Michael came home to find Patricia and 3 of her friends having a pool party. They'd moved his patio furniture, set up speakers blasting music, and scattered wine bottles across his deck. This time, Michael was firm. He asked them to leave immediately and explained that this was private property. Patricia's friends had left, embarrassed, but Patricia took her time gathering her things. As she passed him, she'd said, You know, technically this pool sits where both our properties meet. I've been researching property laws. You might want to be nicer to me. The statement was absurd. The property survey was crystal clear, but it lodged in Michael's mind like a splinter. When he checked his security camera footage the next day, he discovered Patricia had been using his pool almost daily for weeks, always timing her visits for when he was at work. She'd even given a key to his pool gate to her friends. Michael called the police non-emergency line. The responding officer, a bored-sounding dispatcher named Williams, took his information and explained that unless Patricia caused property damage or refused to leave when Michael was present, it was a civil matter. Put up better locks, talk to a lawyer if you want a restraining order, Williams suggested. Michael installed a new lock on his pool gate the next day. Patricia cut through his fence. He discovered the damage on a Saturday morning, a section of his cedar privacy fence, carefully removed and propped against a tree, creating an open doorway between their yards. Patricia was in his pool again. When Michael confronted her, she'd turned to him with a smile that didn't reach her eyes. "I spoke with a real estate attorney," she said. "He confirmed that your pool creates an attractive nuisance that decreases my property value unless I have access to it. This is community property now, Michael. You should have thought about that before building it so close to my side." Michael's hands had trembled with rage and disbelief. He'd retreated to his house and spent the weekend buried in property documents, survey maps, and permit applications. If Patricia wanted to play legal games, Michael would show her what happened when you challenged an engineer's documentation. He photographed everything, compiled every receipt, and prepared for war. The certified letter arrived Monday morning, and that's when everything changed. The courthouse steps felt surreal under the October sun. Michael had spent $4,000 on his attorney, Marcus Chen, a property litigation specialist who'd reviewed Michael's documentation with growing amazement. "I've seen entitled neighbors before," Marcus had said during their consultation, "but this is genuinely delusional. She doesn't have a case, not even close." Still, they had to appear. Patricia's attorney, Richard Moss from Moss & Associates, had filed a formal adverse possession claim combined with an attractive nuisance argument, demanding joint ownership and $20,000 in damages for emotional distress and property devaluation. The courtroom was smaller than Michael expected, paneled in dark wood with fluorescent lighting that cast everything in harsh relief. Judge Catherine Morrison, 58, had a reputation for no-nonsense rulings and impatience with frivolous litigation. She took her seat at 9:47 a.m., reviewed the case summary, and looked up with an expression Michael would remember forever, profound skepticism mixed with mounting annoyance. Richard Moss stood first. He was mid-40s, wearing an expensive suit, and he projected confidence that wavered the moment Judge Morrison interrupted his opening statement. "Counselor," she said flatly, "I've reviewed your filing. You're claiming adverse possession on a pool that's been standing for 4 years? With full permits? On property your client has owned for 9 months?" Moss cleared his throat. "Your Honor, the attractive nuisance doctrine clearly states—" Judge Morrison held up one hand. "I know what the doctrine states. I'm questioning how you convinced yourself this had merit." Patricia sat at the plaintiff's table, dressed in a cream pantsuit, her expression carefully arranged into wounded righteousness. She'd brought photographs of the pool taken from her kitchen window, printouts of property value websites, and a handwritten journal documenting her emotional suffering. When called to testify, she spoke with the practiced tone of someone who'd rehearsed in front of a mirror. "Your Honor, I purchased my home in good faith, only to discover this massive pool essentially in my backyard. Mr. Torres has made no effort to screen it from view. Every day I'm forced to look at amenities I cannot access, which creates psychological distress and diminishes my property's value." The pool sits on what should be community space and— Judge Morrison interrupted. Mrs. Hendricks, who owned the property at 847 Oak Ridge Drive when you purchased your home? Patricia blinked. Mr. Torres did, but— And during your home inspection, did you observe the pool? Yes, but— Did anyone— Your real estate agent, the seller, Mr. Torres, represent to you that you would have access to this pool? No, but the principal— There is no principal here. Mrs. Hendricks, there's a pool on someone else's property that you decided you wanted. Marcus Chen approached the bench with Michael's documentation. The property survey, certified by the city in 2019, showing the pool 15 feet from every boundary line. The building permits, approved by the Municipal Planning Department. The contractor invoices, totaling $47,000, all in Michael's name. The original purchase agreement for 847 Oak Ridge Drive. Photographs of the fence Patricia had damaged. Security camera footage, time-stamped and dated, showing Patricia using the pool without permission on 14 separate occasions. Judge Morrison studied each document in silence. When she looked up, her expression had shifted from skepticism to open disbelief. Mrs. Hendricks, you cut through Mr. Torres's fence? Patricia's composure cracked. It was blocking my access to what should be shared space. He was being unreasonable. He was enforcing his property rights, Judge Morrison said, her voice ice-cold. Mr. Moss, I'm genuinely curious how you looked at these facts and decided to file. Richard Moss had gone pale. He opened his mouth, closed it, then said quietly, Your Honor, Mrs. Hendricks was very convincing in her consultation. Judge Morrison leaned back in her chair. I'm sure she was. Here's my ruling. Judge Morrison's voice filled the courtroom with the finality of a door slamming shut. The plaintiff's claim is without merit, without legal basis, and borders on malicious prosecution. This court finds that the pool located at 847 Oak Ridge Drive sits entirely within Mr. Torres's property boundaries, was legally permitted and constructed, and has been the exclusive property of Mr. Torres since its completion in June 2019. Mrs. Hendricks has no claim to ownership, access, or damages of any kind. Patricia's face had drained of color, her carefully applied makeup suddenly garish against her pallor. Judge Morrison wasn't finished. Furthermore, the evidence presented shows a pattern of deliberate trespassing, property damage, and harassment. Mrs. Hendricks, you willfully destroyed a section of Mr. Torres's fence, repeatedly entered his property without permission despite being asked to stop, and then had the audacity to sue him for property you knew wasn't yours. The judge's eyes narrowed. This is precisely the kind of lawsuit that wastes court resources and abuses the legal system. Not only is your claim dismissed with prejudice, but I'm awarding Mr. Torres his legal fees, which he will submit within 30 days. Additionally, you will pay for the repair of the fence you damaged, the installation of any security measures Mr. Torres deems necessary, and a civil penalty of $5,000 for filing a frivolous lawsuit. Patricia shot to her feet. This is ridiculous. I have rights as a homeowner. That pool affects my property value. Judge Morrison's expression could have frozen the pool in question. Sit down, Mrs. Hendricks. You have exactly the rights every property owner has, control over your own land and zero control over your neighbors. If you find looking at Mr. Torres's pool distressing, I suggest you plant some trees. If you set foot on his property again, he has grounds for a restraining order and criminal trespassing charges. Do I make myself clear? Patricia sank back into her chair, her hands shaking. The final financial tally arrived 3 weeks later. Michael's attorney fees, $4,000. Fence repair and enhanced security system, $3,200. The court's civil penalty, $5,000. Total amount Patricia Hendricks owed, $12,200. Richard Moss, perhaps feeling the sting of professional embarrassment, didn't charge Patricia for his services, a small mercy that did nothing to soften her financial devastation. But the real punishment was social. Oak Ridge Drive was a tight-knit community of 23 homes, and news of the lawsuit spread like wildfire. Michael hadn't gossiped, he didn't need to. Court records were public, and one of the neighbors, Karen Liu from 3 houses down, had attended the hearing out of curiosity. By the time Patricia returned home that afternoon, the neighborhood group chat was ablaze with screenshots and commentary. The woman who'd hosted elaborate backyard parties, who'd positioned herself as a lifestyle expert and social connector, was now infamous as the neighbor who'd sued for someone else's pool and lost spectacularly. Patricia paid the judgment in installments over 6 months. Michael never spoke to her again beyond terse nods when their cars passed on the street. She stopped using her backyard entirely, perhaps unable to bear the sight of the pool she'd coveted. 2 months after the judgment was final, a for sale sign appeared in her yard. The house sold in March, and Michael watched through his kitchen window as Patricia loaded the last boxes into a moving truck, her expression hollow and defeated. On the first warm day of April, Michael invited Marcus Chen over for a thank-you dinner. They sat on the pool deck, drinking cold beer and watching the sunset paint the water gold. "You know what the best part is?" Marcus asked. She convinced herself she deserved it so completely that she actually believed a lawyer and a judge would agree. Michael nodded, taking a long drink. He'd learned that some people walked through life believing their wants trumped others' rights. That entitlement could be dressed up as principle, that if you wanted something badly enough, reality would bend to accommodate you. Patricia Hendricks had learned differently. And as Michael slipped into his pool that evening, the water cool and perfect and entirely his own, he smiled. Justice, whether delivered by a judge or by the consequences of your own actions, was equally satisfying. Across the country in Portland, Oregon, retired Air Force logistics officer Janet Kimura was trimming her roses when her new neighbor demanded she remove her fence because it blocked his view. The neighbor, a tech executive who'd paid cash for the house next door, was already drafting a complaint letter to the HOA. What he didn't know was that Janet had written half the HOA bylaws herself, and she'd been waiting for someone this entitled to test them.